read it out.
Thank you. Welcome back, everyone, to the Committee on General and Housing, and it is still February 13th. We are briefly before lunch returning to the various landlord tenant bills that are in front of us and about which we've had substantial discussion, over a dozen witnesses and many letters. And our next witness in this is Nadine Siebeck, who's an attorney who practices in this area, generally for nonprofits. And Nadine is here, and Nadine, I warn you, people will ask you questions.
No pressure. I have no pressure.
You've been here, you've testified before us, right?
Over the years.
But not, okay, I'll tell you what, let's introduce ourselves.
I'm Debbie Dolgan. I represent St. Johnsbury, Concord, and Kirby.
Hi, Tom Charlton, Athens, Chester, Grafton, and Linden.
Joe Parsons, Newbury, Topsom, and Brown.
Dodge, Essex Town, and City of Essex Junction. Hi, Nadine. Ashley Barley, Fairfax, Georgia.
Mark Mahaly, Plainfield, Callis, and Marshfield.
Emily Krasnow, South Burlington.
Mary Howard, I represent Rutland City District 6.
So tell us your name for the record and share your wisdom with us.
Hi, good morning, everyone. My name is Nadine Siebeck. And thank you for inviting me here today. I'm an attorney. I have a solo practice in Burlington. I cover the state. My only area of practice is landlord tenant law. I represent landlords. And I represent the whole gamut of landlords, but the bulk of my practice is the nonprofits. And I know you've heard from Mike Monty and some of the other housing providers. I represent Champlain Housing Trust and several of the state's housing authorities. So this is all I do. I live it every day. I've seen it all. And it's been 35 years coming this fall that I've been practicing. So I've been doing this for a really long time. I've seen a lot of changes in the legislature over the years. I've been a part of a lot of the last big changes that have come across your desks. So I'm going to talk generally about proposed bills, primarily on 772, because I think it encompasses a lot of the same issues that were raised in some of the other bills that were presented. So, and I know you've heard a lot of testimony, so and I've watched a lot of it, so I'm going to try not to repeat what some of the other people have said. But I can tell you that it is a long process. It is not short. And there needs to be a process fair to both sides, the landlord and the tenants. And how do you achieve that middle ground? And on average, I would say from the starting of your case forward, if the tenant does not respond, you're looking at a minimum of 3 months. If the tenant answers the complaint, you're looking at least 6 months plus. Things have changed in the judiciary that I think it was about maybe a year or two, time flies. Now we have to include answer forms with the complaint. So, and the summons has also provided more detail to the person being sued as far as how you respond, who you have to copy, how long your time frame is, things like that. So, and it's written at a level that people can understand. I also get a lot of calls at my office from tenants, happy to talk to the tenants. I tell them, here's your deadline, this is what you need to do, things like that. And goal of the landlords, and I've heard some of the testimonies, so there's a lot of wonderful, wonderful landlords in the state. And I know you've heard some stories about things that tenants have done. And granted, there are some really bad landlords out there too. But my clients are wonderful. They're in the business of providing housing, safe, affordable housing. And this is what they do. And there are rules to comply with. And you have to pay your rent. You can't go months and months without paying your rent. Landlord has bills to pay, property taxes, etc., things like that. So process the way it is now.
Nadine, I'm going to interrupt you because you did refer to one thing.
Yes.
We have had testimony that a complaint has to have the answer attached to it, instructions.
Right.
And we've had testimony that this has resulted in fewer defaults. Do you still see a lot of defective answers where there's a problem, that they didn't do it right, or they, a lot of, I'm not talking about where just no answer.
Right. I don't think there is a thing as a bad answer, as long as the tenant files something. All they have to do is fill out the notice of appearance form and they're in the case, they can't be defaulted, things like that. And the notice of appearance, it's just their name, address, phone, email, how the court can contact them. And then the answer, they can fill it in. They can always, you know, if they get legal counsel later, legal aid can help them, or legal services, they can amend their answer if they want to do that later. So they're not prejudiced by just filing something. I mean, I guess some tenants that just write agree to everything or literally just file the notice of appearance. And I have noticed a sharp decline in the number of defaults since that law was changed with the judiciary of having the answer form provided with the complaint package. So I have noticed that. I think that is increasing the number of cases that are still pending with the court because it's defaults, you move them very quickly through. If the case is pending, it's more court time, more hearings, things like that. So the process itself, and they're costly, and I'm sure you've heard that. So the state filing fee is $295 plus the Odyssey fees. The sheriff's fees are $75 per person plus mileage. Not so much postage anymore because most sheriffs are emailing their back, which they. But I can tell you that it's costly. If the tenants want to stop a non-payment case, they do have to pay the court costs. Those are going to run about at least $500 on your average eviction in order to stop the case. These are all costs that the landlord needs to pay. They may not be reimbursed for those costs. There's also the cost of the attorney. And I think I heard Brian Armstrong or somebody testify that there is a decrease in the amount of landlord lawyers out there. And I agree with that 100%. The landlord tenant bar is shrinking. It's becoming very complicated to bring an eviction case. If you do not bring it properly, you can be subject to dismissal if you miss one step. So, yes, question about that.
Please.
I have heard, so we've all heard from tenants, landlords. One of the things I've heard regarding no cause eviction is a landlord will bring forward a complaint and then at the bottom still fill out a no cause as like a safety net. Have you seen that as well?
Well, I usually advise my clients, bring everything you can.
Okay.
If it's a tenant that they're not willing to work with, there's usually some other issues.
Yeah.
If it's just a non-payment issue, then give the tenant a chance to get caught up and redeem. But the safety net would be the no cause.
Okay.
Yes,
You mentioned that those court costs don't always get covered. I thought I saw like our statute says that the costs, is that only if if the case is found against?
Right, so if the tenant wants to stop an eviction, they have to pay the rent and the costs. But if they don't redeem or get caught up and they do end up getting evicted, the landlord's gonna have to eat the cost.
Okay.
Okay, good, all right. So there's the cost involved, things like that. And I was just gonna say the landlord bar is really, I got an email this morning from a person, they represent several mobile home, or they own several mobile home parks in the state. She emailed me in 2024 and she says, I haven't been able to find a lawyer. Are you taking new clients yet? So I get this repeatedly. So that's another crisis. I get, it's just bad. It's really bad. And I can tell you that in my almost 35 years, that this is the worst I have ever seen it as far as the number of evictions. It is out of control, not just for, and I'm sure Judge Sone or somebody else or Terry from the court can give you the numbers as far as how many evictions have been filed. I can tell you that I resolve a lot of evictions before they get to court. I serve first, give the tenant an opportunity to pay before we start the case. If they do, they pay in full, great, we don't start. So I have a significant amount that don't even make it to court. Then there's the amount that do get to court. So it's, I have 4 assistants right now who are working full time. That's how busy it is. And it's not just non-payment. I'm talking cause. I can tell you cause evictions are the worst I've ever seen it, as in drugs, as in noise, as in mental health issues. It's challenging right now. So since I mentioned cost, let's talk about that for a quick second. I would recommend there's gotta be some change as far as shortening the process for cause eviction, such as drugs, violence. In 772, I absolutely loved the additional language about harassment, violence against staff, landlords, agents, and the landlord. I can tell you that is on the rise. I had several assaults this year alone against property managers. Your property managers, especially in the nonprofit world, who are in, the mission is to provide housing for people and to serve, to have your job, to have be threatened. I've had property managers come down with PTSD who have had to leave their field because of the violence. So, and then it's not getting support from police and the system itself. And one property manager this past year, the tenant came in, had an episode, punched her in the face, and then destroyed her computer and printer. And now she is trying to deal with that and getting the other side to understand there's reasonable accommodations and things like that, but people are scared, property managers are scared. So having that additional language in there would be a welcome, very welcome right now. And then cause-wise, I can tell you that if you have the right tenant and they know how to manipulate the system, drug eviction, I had one maybe 2 years ago, took 1.5 years to get them out. They filed counterclaims. By the time I got to the trial, it was about 1.5 years in. Meanwhile, the drugs are still going on. Meanwhile, Burlington police are still investigating, and they brought a whole other drug case, like the second one within the 1.5 years because of the traffic. My client had cameras on the building, gave it to the police. 80 to 100 people a day were going to this unit. They got a warrant, went in. This is what it's like out there. It's, and you've heard about the needles. I can't tell you. And I think I hear Sheriff Gamlin's coming in next week. He can tell you about what he sees in his work for enforcement of
Yes.
this.
I'm not trying to
Oh, no
interrupt because I know
We
that
always
this is the
interrupt.
reality. I'm not trying, but I am. I think part of the struggle that we're facing in the housing committee is that we want to help. We want to help the tenants and the neighbor tenants and the landlords and everybody who's trying to do the right thing in house Vermonters. How do we still protect due process when, like, an accusation of criminal activity should require some sort of proof? And so do you see that 772 threads the needle? Is there different language that you would recommend in how we address no cause versus, breach of lease and those activities? I mean, I feel uncomfortable just saying, criminal activity because I feel like that requires proof, whereas like disturbing, neighbors' peace and tranquility is.
We had a discussion, you should know, where because partly of concern about constitutionality and the whole criminal thing, people felt much more comfortable focusing on any actions by a tenant that threatened the health or welfare
Or tranquility.
or just health health and safety. We're putting in one box, if you will, activities that threaten the health and safety of the landlord, the other tenants, the landlord's representative.
Right, and I agree with that, and we have a little bit of the law right now. This would just expand the categories of what would entitle you to bring a shorter under the current law. But to even shorten the notice or to be able to get into court, they still have their day in court. They're still going to be able to present it's the landlord's burden. It is ultimately the landlord's burden to prove that the lease has been violated or the law has been violated. And if the judge finds yes, then that person has to go. I can tell you that I only bring cases that I think we're going to prevail on, and I make my clients work really hard to build their case, especially if it's not something immediate, like the police went in on a warrant, they found like a kilogram of coke or something like that. That is bam, right? Those are the fast ones. Those we can start right away. Or an assault by one tenant against another tenant, that is an immediate, we start right away. Other things you have to build. noise violations, things like that. Smoking, you give them an opportunity. Hey, you're violating your lease, stop smoking. That's a big issue. Had several fires in the last few months, because of smoking in the buildings, which are not allowed. So it's, there's still a day in court. It's just how fast can you get into court? That's the key. Okay, all right. Again, I don't want to take away anybody's rights. You get your day in court and we go forward. Speaking of that, there's jury demand. I know there's some language in here about taking away jury trial rights. I do support that. This is a property issue. This is a landlord-tenant issue.
See,
Tenants do file answers with jury demands. I've seen that on the rise. It's either a delay tactic because it will delay your case. I mean, they could delay it right up to the jury draw. I can tell you my experience. I have only had myself 2 jury trials in 35 years, and they were unrepresented tenants who actually got that far. I prevailed on both cases, but it dragged the cases out significantly. Either tenants use it as a delay tactic or they don't understand what a jury demand is. And legal services or legal aid have forms, like standard forms they give to tenants. They instruct them how to complete it. And some of those forms have a jury demand box. The tenants just check them all and they submit them. So that will automatically delay the case. So
how long, you were saying 3 months if there's no answers, 6 months if there's an answer. What if there's a jury trial?
So it really depends. When Judge Katz, I don't know if anybody remembers Judge Katz, but he passed away maybe a year or so ago. Great judge. If he had a landlord tenant case that came in with a jury demand, he put it on to the next draw. So a lot of it depends on how the judiciary would handle the jury demand.
I just have a quick question about a lot of times when you do pay rent into court and the judge says, like you can pay 2,000 and then in 2 weeks you can pay another 2,000. I would like to see that eliminated and just have one amount.
Let's expand that question. One of the questions that has been circulating, I mean, as we've grappled with this, we have heard repeated testimony that the problem with the current system is it takes a long time, and during that time, you're often not paid rent. And then as we became familiar with at least the law itself, as it's stated, there's this pay your rent into court. The landlord can request that you pay your rent into court. And then if people don't pay the rent, then there's a rapid process to get them out. And people are wondering like, well, so what's the problem?
That's the problem.
If I might be so blunt, am I saying this right?
Yeah, that was just my reaction after reading that.
Well, but okay, we're new at this, so
Oh,
help us
yes.
out.
Let me
Okay.
help you. So pay rent into court motion is to get them. It only applies to the current rent going forward. It does not apply to the back rent. So one issue is getting a hearing scheduled. Some counties are taking 2 to 3 months to get you in for the escrow hearing. So there's the issue of scheduling the judiciary. Once you get in, there will be a court, if the court finds, or you stipulate with the other side, that rent is owed, they're behind in the rent, and then how much the first payment is. Then that's the order that issues. I tend to find that the tenant can usually make the payments, right? So if they haven't paid rent in 6, 8 months, some of them are able to pay the rent going forward and preserve, and actually they buy time that way. Some tenants can't afford it because it's not sustainable. So once the order issues, a lot of them, so let me back up a little bit. There's, I think, 3 counties left that have the landlord tenant clinic where Legal Services Vermont provides assistance to, I think it's, I think Rutland was canceled, Washington County, maybe Middlebury and Burlington. So legal services and pro bono attorneys are there to give tenants advice. We work really well together. I know the minute if a tenant is not going to be able to make it. So we tend to structure the order so that the tenant will get at least 30 days or so to figure out where they're going to go if they can't make that first payment. If they don't make the payment to court, we file a motion with the court. The judges are very fast about issuing orders. And then it's currently a 7-day writ. So once the tenant's served, they have 7 days to go. But if the tenant continues to pay the rent, the current rent, It just delays and then you wait for your trial date to come. And at some point, you'll have a trial and the back rent will be addressed. And if the tenant's able to redeem, then they stay. If they don't, then they have to. And those are non-payment cases.
Just to clarify, so right now, the way the law works, when you file your complaint, you can file also a request for rent to be paid into court. But it only is the rent that's due the month of the order, or what rent is it?
Right, you could technically ask, it varies by counties and judges. The law is from the date that your tenant was served or the case was filed, whichever happens first. Some judges, because of the delay in scheduling these hearings, are saying from the date the motion was filed, which could be later. And then some judges, if there's too much of a delay, just don't think it's fair for the tenant to have to come with 3 months, up to 3 months or more of rent. So that's all judiciary issue, but for the law, it's only from the time the case actually starts with the court.
Is that because there's an assumption that you have to prove that there was non-payment?
Right, you have to prove that they owe rent, that they're entitled, that they are obligated to pay rent and they failed to pay,
Yeah,
and that their tenancy was properly terminated. Right, that's how that works, yeah. But that's how escrow works, and it's not, I don't use it as the be all end all for every case. I try to resolve the cases with the tenants. And there's a lot of great tenants out there, and believe me, I see them struggle. I see it every day. The kids, something breaks, this happens. So I'll put a quick plug in for the back rent program. Continue to fund that. It saves a lot of tenancies, and these are sustainable tenancies. So your car breaks down and you get behind, or somebody gets sick. I mean, it happens all the time. Or you lose your job and you're out of work for a few months. These are the tenants that this program is there to help. It has to be sustainable. They won't get the assistance if it's not sustainable.
I'd like to return to this, back to the rent under court program.
Sure.
Help me make consistent that if there's an answer, you're talking 6 months before resolution, and presumably, and I've heard here, the landlord is not fully compensated for the loss of rent during that time. But the rental program, as you described, it sounds like it could take care of that. So I'm missing something.
Right, so the rental program, so that's another issue, I guess, is that program, there are certain requirements in the program.
No, I don't mean the rental
Oh.
not the
arrears.
arrears, the
I meant-
payment into the court.
Payment
Oh, okay.
in court.
And I'm sorry,
Okay, so the payment, what we're wrestling with is sort of what appears to be a contradiction, and maybe you can help us see that it isn't. What we hear is that it takes 6 months to bring a case and get a tenant, and get into possession for a landlord. And what we've also heard is that, in addition, what's wrong with that is not just that it's 6 months, that it's 6 months largely without rent. And so you've lost the rent during that time as well. But on the other hand, we see this program that says that a landlord can file to require rent to go in court on day one when they file the complaint. And then the tenant, if the tenant can pay rent, well, they can pay rent into the court. And then if they get evicted, the landlord gets all that rent. So what's the problem? You see what I mean?
And
right,
in fact, ask in the statute anyway, it says that if you ask for that rent from and the court demands that rent, and the person does not pay it, that then immediately they're found in default. And so
So in other words, we're kind of wondering.
why are we here?
yeah, why are we here? Is this really a problem? Why change anything if you can
Right.
do this for
because
non-payment?
for non-payment. So if you get an order to pay rent into court, that's only for a certain amount. Usually there's a large arrearage that they still have to pay. The landlord will get some money, and that is the helpful piece of the escrow motion or the escrow order. But the bottom line is there's usually still a lot of money out there that's still owed to the landlord. So there will be money coming into the court for escrow. And at least the landlord, I always tell a client, at least you get something, right? If they pay it to court, great. At least you're gonna get something. At some point, we're gonna deal with the back rent at trial and how much they owe. So it's not a be all end all on the escrow.
Do most landlords use the rent, if it's a back rent issue?
Yeah,
If it's a non-payment,
Right.
it's sort of automatic.
yeah, we file those right away because either the court will schedule the case for a status hearing as soon as they get the case in. I'd rather have it be an escrow hearing versus a status. A status is just giving the judge that, hey, this is what's going on with this case. I'd rather have an escrow order issued. At least we've got something in place for the landlord to have the current rent coming in until the case is resolved.
Go ahead.
I mean, it's sort of like, I would think it's sort of incumbent on the landlord to have tried to work to get paid, but if they have this ability, are you saying that they go a long time without getting paid because by the time they are given a court date to appear, that there's been perhaps months of non-payment?
Right, so I'm gonna go out on a limb, and I'm gonna say that the vast majority of landlords try to work with the tenants. They just want the rent.
Yeah.
And then they'll say, oh, I'll pay next week, and it comes, and next thing you know, the tenants are behind 2 months. And then by the time the process gets going, we're up to 3, 4, 5 months. I can tell you that a lot of my nonprofits, and I know Mike Monty has addressed this, they have at CHT, Champlain Housing Trust, they have a resident services program. They do everything they possibly can to resolve these cases with the tenants before they have to send it to me.
Yeah.
Sometimes by the time it gets to me, and that's not just CHT, I'm talking across the board for my nonprofit, and my housing authorities and my subsidized housing providers, I am seeing staggering numbers of rent. 12,000, 15,000. There's no getting out. I mean, there's no getting out from under that. They're really, how are they going to come up with that kind of money in order to stop a case? So I think that's, landlords try to work with the tenants, and if it falls apart. And then one thing with this, the landlord relief program is that you actually have to have a court case. So at some point, you can all explore the program requirements for the eviction prevention program that's being through the Vermont State Housing Authority that you're funding. Because a lot of my clients will not participate in it because of several requirements in the program. So there's that whole other issue. But
Not the rental arrears program.
yes, that one. So that is the background, right,
Yeah, but for here,
for here.
so what you're saying is what you don't get paid for typically is the period of time when rent was due, but you've been working with the tenant. Then you don't get paid for the time between the time you finally give up and file an eviction and the time that the hearing is set, which you say in many cases is several months.
Right.
Is it typically that way?
It is.
Yeah.
Yeah.
Then at the hearing, at that point, the judge probably will order current rent into court, but not back rent.
Back rent's another day. It's only from a certain time period, and a lot of times we reach a stipulation or agreement on the order with legal services or in these clinic
And
situations.
is it usually, though, an order for the full rent going forward, or is it
Yes.
sometimes less?
It's always at least the amount of the current rent.
Debbie?
I just have a question we'll stick with non-payment of rent.
Sure.
But do you see like damages going along with that non-payment of rent? So like when let's say the tenant loses the case or whatever and they're out and you get the unit back, are there damages along with that back rent?
So, yes, I mean, there's a lot of good tenants that just can't
Yeah.
pay and they leave the place in good shape. And I always tell them, leave in good shape because it's gonna hurt you in the end if you don't. But there's a lot of bad out there. 2 weeks ago, as I was driving to the airport in Logan, a client called because a tenant had broken back into the apartment. Landlord was in possession, tenant broke back in, the neighbor called the sheriff's department. I ended up calling the sheriff's department. They literally broke in, they took the door down. I said to the deputy, I'm like, you gotta go back out there, you gotta get them out, they're not supposed to be there. So then he goes back out, he was assaulted. And the tenant also deployed the fire extinguisher, and I've seen the pictures, the place is destroyed from the fire extinguisher. A former tenant has been charged with 5 different counts and thankfully charged with something. So this is what you're up against. If it's bad, it's bad. And I can tell you honestly that I've never had so many units literally boarded up with plywood. We take possession now and we board them up because they keep breaking back in and causing more damage. So
So that's, am I right that as a legal matter, paying rent into court doesn't deal with damages?
No.
That's dealt with at the trial finally.
correct.
And at the trial, if there's judgment for the tenant, then the rent that was paid in court goes back to the tenant.
That's what the court finds if there were, say, habitability issues, things like that, correct?
Or if they just, for some other reason, lose, it could go to the landlord. But there, the issue of damages to the rental unit is something that's separate. And it ends up, if a judge can award money damages for the damage to the unit, but then it would be up to the landlord to collect that from the tenant, right?
Correct. And I can tell you that the vast majority of my tenants being in the subsidized nonprofit world they are pretty much judgment proof, which means uncollectible, never gonna see a dime. So the landlords are out thousands, plus damages, plus legal, plus, and it adds up over time. And they're uncollectible. You collect the fuel assistance, you're uncollectible, so security, disability, things like that. So
Go ahead.
Can you
please.
call on me?
Yeah.
I was waiting for him to call you.
So, I feel like a lot of our, if we're trying to paint a picture, we kind of have this just scene of horrors, right? And I'm trying to, I'm
Bad cases,
in the-
yeah, it is a scene of horrors, but
in the bad case,
Yeah.
right? Can we try to delineate between the non-payment cases versus the damage, criminal activity, intimidation, violence and aggression? Or do you see a lot of overlap? Like my instinct, right? And we're just, as I say often, we're citizen legislators, right? We're here just because of our, sense of right and trying to be a voice. So I'm trying to understand, is the person who's committing the really disruptive criminal stuff, do they tend to actually pay their rent so that you have to?
as they do, and then we have to go after them for the actual cause piece. But I can tell you that.
But so then so
Right,
You see where I'm going with that?
Put it in a picture, so here's the picture, there's a process. What do you want to put into the process? How much time? It's all about the timing. There's still a process, right now, what this bill proposes is to shorten some of the timeline. There's still a process, it's just the tenants don't get as long you can start sooner if they don't pay. And I can tell you that, non-payment doesn't concern me as far as the notice at all. Because most of my clients are bound by the CARES Act and federal regulations, which is 30 days. So I really don't care about that. I care about the cause pieces. Can we shorten the time period on that to get those cases going sooner rather than later? And same when you're in the court process, can you do,
Yeah.
why is it a 14-day writ? It should be a shorter day, 7-day writ, things like that. And a lot of cases, we work out dates, move out dates, or the judge can also give more time. The judge has the discretion to say, I'm gonna give you 30 days to move out, or I'm gonna give you 60 days to move out. I've had judges do that recently. So the courts still have the discretion to give more time, but the law sets the minimum.
Actually, while you're there,
Yes.
we would like to confirm what we understand. I warned you from our counsel, who is interpreting a statute which we have stared at and think is at minimum horribly written. And at maximum unclear. We were trying to combine and understand the effect after a writ has been issued. And served.
Right.
Okay. How much time before the landlord can actually get rid of the tenant's stuff? And looking at the ordinance and the statute and it, whichever is later language interpreted, we're told by council that it meant after service, unless there's a counter by the court, the sheriff can go and remove the tenant no sooner than 14 days after service. And that after that date, the landlord cannot dispose of the property after they're put in possession. They still have to wait 15 more days to do that. Is that your experience?
No, and I was part of that legislative change, so
So my apologies if I've insulted you, but not.
never insult me, Mr. Chair. So I mean, it's the way that was written, because at the time, the law before the current was a landlord had to hold, it was really crazy, had to hold the property for 30 days if it was under $1,000 or 60 days if it was valued at over $1,000. And then it went to just 30 days. And it's like, the argument that we brought to the legislature was, well, why, right? The landlord's just gone through this lengthy, expensive eviction process. Why should they have to then continue to store the tenant's belongings? So the way the law is now is that it's 15 days. It coincides with the 14-day writ. Day 15, landlord takes possession and can dispose of the property.
I understood you.
Yeah, I know. I want to tell you, although the statute is not in front of me, the
Right.
statute says, the statute says,
Yes,
it says 15 days from the issue, I'm talking about the time when they can dispose of the property.
right.
Yeah.
15 days from the issuance of the writ or service of the writ.
No, issuance, not the
Issuance of the-
service.
Service of the
Right,
writ.
service. Yes.
Or
Or 15 days after
Wait.
the judge speaks.
or whenever the landlord is put in possession, whichever is later. Okay,
Yeah.
so if it's 15 days, so if the first day is the writ's served, the 14th day, the landlord's put in possession, the statute says another 15 days. It says whichever is later.
But
So
it
how
says-
does that end up? You're saying what we want to do, I think, which is 14 days plus the next day you can.
Right.
And you're saying that's the law.
Right.
Okay, well, we have some
It's-
writing.
It's
to do.
whenever the landlord takes possession, at least 15 days after they dispose. of it.
Whichever is later.
So we're gonna, okay, so what we want to do is what she says the law is currently. Okay,
Which-
Oh.
yes.
Yes.
That's
Yeah,
right.
she's, so I'll have to,
You
I'm
got some
talking to
stuff to
Cameron this
do.
afternoon.
You have a
We
lot.
have some writing to do. Okay.
Oh,
We
so-
sponsored
So
you.
that's, how much time do I have?
You take, I have to leave it now, but. she's
I have to
gonna go-
leave now.
No, no, I have to
Just
go
now.
downstairs, but
Just
she's gonna take over. We have a hard stop at noon, so it's 20 minutes. If it's less, we have another witness, but take 20 minutes. I want people to ask questions, okay?
Okay, sounds good. But it's a process, everybody. It really is a process. So again, I'm just looking to bring it down a little bit. And there's a lot of moving pieces. So there's the statute itself. There's also the court, how burdened is the court? The courts are very burdened. We have a new judge that is helping out on some of the landlord docket now in Burlington, which has been very, very helpful. It's kind of moving the cases along a little bit faster, but still there's time. And then there's the sheriff's department who has to serve these things. And especially in my more rural areas of the state, they have to drive out there. Sometimes they're driving 30, 40 miles to get to the property. And then they have to make multiple attempts. And sometimes the sheriff's departments take time to get the paperwork served. And then there's some issues with the sheriff's departments in general, just not getting the civil service done. So that's another delay for the whole process. So if you can shorten some of the process, I think that would be helpful. No cause, let's talk about that. I support keeping some sort of no cause in the law. I think landlords are not going to take as much of a risk on tenants if they can only evict for cause. I can tell you that, again, landlords do not want to evict. If things are going great, everything's good, they don't want the expense or have to deal with a vacancy. So I think you can we can keep something in there if you want to consider something, maybe adding more time to the notice. Right now it's 30-60 for written lease or 60-90, or no, 30-60 and then 60-90 for no cause. If you want to lengthen that, give more time, great, because I think some of the arguments made by my esteemed colleagues are that the tenant gets a no cause, they get 30 days notice, that's not enough time for them to. So why not build in more time, right? So we extend it, which is fine, because if it's a no cause, then fine, we're just gonna, I as a landlord, am gonna give you more time to find another place to live. So that might be some way to kind of appease that part. And we talked about no jury trials. We talked about expedited cause for drugs, violence, things like that. And abandoned property, we talked about that a little bit. But, oh, sorry.
Oh, I was just gonna bring up the TAC orders. We were,
Oh, I'm so glad you did. That's like down here on my list. Thank you.
sorry.
No, that's
spoke
great.
too soon.
No, you're great. The TAC orders, I think that was in 688, I believe. I would love that, love. So if you can work that in, and that particular provision talks about alternative service. There's a split with the judges right now. Some judges will give you a blanket TAC order, and a TAC order is literally the sheriff can't serve the tenant, made multiple attempts, either the tenant is blatantly dodging the sheriff. It allows the sheriff to literally tack the paperwork to the door. Some judges will give you blanket for the entire case, so for your summons and complaint, your writ, everything else, and some judges will make you do it piecemeal, so that just drags it out. They've already dodged the first service, they're definitely gonna dodge the second service. I would love if the legislature could enact a law that said, court that issues one order is good for the entire case. That will just save a lot of headache.
So in other words, you yourself and your property, you put a sign up. Sorry, I'm a little
Oh, that's okay. It is a
more
court,
unfamiliar.
it is a court order. So when you start your case, you have to serve the tenant with a summons and complaint. It goes to the sheriff. If the sheriff can't get the tenant, they have to make so many attempts at different times of the day.
Mhm.
Sometimes the sheriff goes over there and can hear somebody inside and then knocks and then dead silence. Or you hear, don't answer the door, or you see people running out the back, or, I mean, there's so many
Right.
ways to dodge service, but then the sheriff sends me an affidavit. It outlines what happened with the service. I file a motion with the court. The judge rules. If the judge says that we're gonna issue a TAC order, it's alternative service, will allow the sheriff to literally tack all the paperwork to the door. I also have to mail it to the tenant, so they have it. So it's tacked. Some judges won't give it to you for the whole case. You have to come back for each order.
What are the different orders? Sorry.
It's the same, so
Oh,
there's the
each
summons.
attempt.
So there's multiple services in an eviction. There's a summons and complaint. If the tenant does not show up for the escrow hearing and an order is issued, that has to be served. There could be dodging service on that. There's also the writ and judgment. If you get to that point, they can also dodge that. So there's multiple services that they need in an eviction case. And having to go back to the court each time is time consuming and costs you more in sheriff's fees and things like that. So having one order that would apply to the entire case is just so much easier.
So currently, in the draft and discussions that we've been having, is that similar to the language that you'd like to see, or?
So that's currently at 488,
Okay,
but I don't.
688.
688, thank you. 688. But it's not, it's
722.
not 722.
but we had talked about maybe. I've spent a lot of time in the judiciary room lately.
Oh, we're aware.
Which ended today because they voted out, but anyway, talking about TAC orders and whatnot, so it's definitely something that I think we're gonna talk to, the judiciary guy about, because there's some conflicting opinions.
And he'll be here on Tuesday.
Excellent, so we'll talk about it.
That'd be great.
Just to clarify on, so I know that 68 does have that TAC order.
Yes, that's.
772 changes actual notice to include things like putting it on the door and mailing it. Is that the same
little bit
Things are
different.
different. Okay.
Different, yeah, so
Okay.
that in 772, that's the actual initial notice, so in order
Just the
to,
initial note.
just the initial notice, which is, I love that, it expands it and adds email. Because so many people use email now, and then as far as either delivering it to the door and mailing it, it just gives landlords more options to get the initial notice there.
Yep.
When I first started, it was sheriff or certified, which was costly, and then you had to prove that the tenant actually got it, so this expanding in 772 is great. It gives more options for the landlord to deliver notice and prove that notice was sent.
Yeah.
Definitely,
Thank you.
no problem. Rent control, I know there's some piece in 772 about rent control. I don't think it would work. The only thing I think agree with would be if landlords couldn't increase the rent more than once a year. Just out of a fairness piece, because you shouldn't get a notice like every 60 days or whatever. I'm just gonna keep jacking the rent up. Landlords should be able to know within a year if they need a rent increase. So limiting that, I don't have a problem with that at all. The security deposit, I'm okay with the 2-month limit statewide. I think Burlington and Barry is 1 month. But if you put a cap on that, I mean, I don't really see landlords, because I work in the nonprofit world. I don't really see landlords who are charging 3 months of rent for a deposit or something like that. But if you feel the need to cap it because there's some bad eggs out there, then no problem. Application fees,
Can I ask about the security? Yeah. So, I had this, wild notion at one point of trying to, create some sort of proportion between how much you expect of, how much you can charge for security deposit and how much we can shorten the court, like the eviction process. So that there is some relationship between the two, so that there is less of this, like, you're going through the court system for months without any money, without it, can you think of any elegant way to do that? Are we getting there in any way through some of these changes?
definitely. I mean, I think all of the pieces in 772 and some of the other legislation, which again, I think a lot of it is in 772, the TAC order piece was definitely different. The only thing that really stood out that was different in 668 was, I think it's all there and they're all different. So an eviction is one thing. What you require of a tenant for a security deposit is just a whole nother issue. I tell clients, if you don't get the security deposit up front, it's a goodbye. And somebody this week, they're like, oh, they haven't paid their deposit. I'm like, you get it up front or you're not getting it. That's just how it goes. So what's fair to charge a tenant for a deposit? I know Burlington changed its law, gosh, a few years back, because pet owners, tenants that were allowed to have pets, I think the landlord could only charge half a month's rent or something like that. Now I think they can charge a full month's rent for a pet deposit. So landlords weren't allowing it because Burlington only allowed a certain amount for a pet deposit. So that's since changed. I think that's better, but you see how it affects when it's in practice. Everybody has good intentions, but what is the actual practice? It's in effect. So next issue, application fees. This has been, you can't charge an application fee for rental. There's been back and forth, believe me, I've seen my fair share of memos from legal aid on different times over the last several years saying your landlord can't charge an application fee. I do believe there needs to be some clarification on what an application fee is. If you could do that, that would be extremely helpful. There's various language about, and you can work out the technicalities on what is appropriate, but that particular section of the statute really needs to be expanded. So shall not include third-party verifications. Can you charge for a credit report? Because the issue is landlords don't charge an application fee, but then they would charge, say, a nominal or a reasonable fee for a credit check or a criminal check or some other background check. And they pass that along to the tenant or to the applicant. So is that discrimination because you're wiping out a large portion of the population because they can't afford to keep paying all these fees with different housing providers? And it really doesn't matter to me either way, as long as there's some clarification And I love my friends at Legal Aid, but I don't need to see any more letters about, if you're in the subsidized housing world, you can't charge anyways for credit checks. It's only in the private sector. You can charging of credit checks or criminal checks, things like that. And a lot of clients are going to national services for criminal background checks because
Right.
Yeah,
people are
we
coming
saw
in from
that
out of
testimony
state.
from somebody that does that.
Yeah.
Exactly. So it's helpful information. So there's that piece. Confidentiality. I've got a couple of things about confidence. There's so many pieces in this bill. I absolutely love it. So confidentiality. I think we can find some language that will work for everybody. I don't have a issue with confidentiality of eviction records. Let me preface this by saying the initial filing. I have a problem if there's a judgment against somebody, none of those should be confidential. What I find in my practice, and I agree with my colleagues at Legal Aid, that if a tenant who has left a unit, they go to apply for a new unit, and a landlord, now that you can go on the public portal, it's so much easier to find things on the court records that, hey, look, there was a case in 2021 with this same person. They didn't disclose on their application that they had been evicted before. What I find is that some landlords don't go the extra step. They just see that a case has been filed. They don't check to see what happened. If there's no judgment, you can't use it against them. If the tenant, and believe me, if the tenant raised habitability issues and the court found in their fit, that's not an eviction. So there's got to be some protections, I agree, for tenants in those types of cases, because it is hurting them. I've had applicants call me out of the blue, nobody I've ever dealt with, and they're like, I just got denied housing because there's this case. This isn't me. And then I'll have to say no, it's not. If it's a common name, Smith, Jones, whatever.
Mm.
But some landlords are jumping to the conclusion that, hey, look at it, it's the same name, it's the same person, they were evicted 2022. So just for clarity, what can be used against a tenant? It should be only if there's an actual judgment. So, and that means they were wrong and they owed money, or they were violating the lease and they were evicted for cause or whatever it is. But I think a lot of landlords are using that to deny tenants without getting the full picture of what's going on.
I think we also talked about, like, you go to the courthouse and they have the list of, who's on the docket that day. And we were taught, this was part of the discussion, it's like, can we see that? Or is that going to be blank?
Oh, yeah, I don't, the eviction court process is public, the docket, the
Okay,
hearing,
gotcha.
because you can just pull up and it goes away after the week, right? So
Right.
if you look at the court docket, once that week is over, it's gone, right?
Yeah. Okay.
That's the calendar. I need that. I know I'm gonna get access to it. I always triple check where am I supposed to be at any particular time, but it's very helpful to.
Yeah, I just want to clarify.
Yeah, and that's why tweaking, there's tweaking. I'm not supporting anything 100%, but I think some work can be done around confidentiality, because you don't want to prevent tenants from finding this.
Yeah, I was looking for it here just to get the wording correct, so forgive me.
Sure.
Reading it wrong language. This allows, Bill 772 allows a landlord to kind of file like an affidavit or whatever, I think, however it's worded, of the crimes, just because there's so many of the tenants who don't want to be part of evicting their neighbor on record. One of the things I suggested was that be, and I'm guessing that can be filed with signatures of tenants. That stay forever sealed. Because it's like, it seems to be one of the problems when you're like, hey, we have somebody doing this, and it's a little hard to prove. Well, it's if 9 other tenants are also in the same boat as the landlord,
Right.
that seems like it would hold a little more weight with the court.
Yeah, and so in the no cause world, this is why the no cause world is great, because if you have
Yeah,
those
exactly.
issues, then you don't need to have the name. That's another piece of why you go no cause in the no cause situations for market private landlords, because then you have to drag the neighbors in if you can do that. I haven't thought on that, but it's the piece in the proposed bill as far as an affidavit being submitted with the notice, I mean, that just needs to be tweaked. I don't think you need an affidavit and a notice. I can tell you that we could do some language in there that talks about, which I use in my subsidized world, which is required under HUD regulations, that you have to specifically detail the basis for the eviction in order to provide the tenant enough information to provide a defense to the case. So if you ever see one of my cause notices in a subsidized housing world, I mean, like some notices for landlords are like a page long. If I have a problem tenant, I think I just wrote one a couple weeks ago, 10 pages long, and it details all of the violations, what happened, when, et cetera. That should be enough. I don't think you need an affidavit. I think that's just another layer of
That might be,
Layered out.
yeah, is that, I'm just thinking of the 4 unit people having the ability to write 10 page.
No, I don't.
right, and it's hard because you have to build your case and I can usually, and just talking about cause evictions because they are difficult, they're really difficult. And I try to settle them by getting the tenant out and agreeing to leave, but if they don't, then you do have to get the neighbors. And I can usually get them to come together. I have my ways, usually promise them lunch and their witness fee and things like that. And I can tell you that it's very cathartic for them. I think in all the years that I've been doing this, I've only had one neighbor that just refused. We offered to put her up in a hotel, move her, pay for her move. It was that bad. She just wouldn't do it. So sometimes I pray that I have the police department, I have observations from the police. That's why this drug case I talked about was a year and a half. I agree. I didn't need any of the neighbors because I had police observations and evidence of drug activity at the apartment. If you don't have any sort of police activity, then it comes down to the neighbors, how often people are coming, how they disturb them and how people are. We have camera systems in a lot of buildings now, which have been great. I can use that and try not to bring in the neighbors. So, but they're hard. They are the hardest cases. So,
So we only have a few more minutes.
I just, but if you have one first, go, because I've been, so, if we're talking about, you've mentioned and echoed what we've heard in committee about the convenience of no cause when there really is a cause. And you just illustrated one of the reasons, but I thought I also heard you say that we could lengthen the notice for no cause. So how would that work with the person that, like, in other words, you would be avoiding the court scenario and maybe the intimidation and, you know, having to build the case, but you would still have the person in there. They would know the date by which they would have to be out. Would it not lead to the same problems, or is it just what, well, at least they'll be out by the end?
and they may or may not leave at the end of the notice, and that's a whole other thing. I've had some tenants recently that have moved out at the end of a notice. Shockingly, because for a while there, nobody was leaving and all the cases were getting filed, but more are leaving because they don't want a record of eviction on the record. So we try to work something out with them. I can tell you, more clients offering money for tenants to leave. Hey, I'll give you $1,000. Give me the keys. Never taking it. And some are just digging in because they know there's nowhere to go and they'll just write it out for however long they can get in the court process. Yeah, it's challenging. So I have one more. I have one item left. We're doing so great. I can't believe it. This is awesome. So the last thing I wanted to talk about, because I think we covered everything else, was the trespass provision. Please, oh gosh, I'm begging. This is my beg. Okay, I've been trying to get this for years, like years. So the trespass situation is, and I would say you go a little bit further than what's written in 772. Please give us some authority that if someone is evicted, I don't care why they were evicted, non-payment cause, straight across the board, they cannot come on the property. They are banned, period, because this is the game that goes on. Tenant gets evicted, tenant moves in with neighbor. Neighbor knows there's a 14-day guest policy. That tenant gets to stay there for 14 days. Then they move on to another resident, and until they finally, because then you got to deal with the tenant that's letting them live there, and you're like, hey, this is a problem. They can't be living with you for more than 14 days. It has gotten more and more of a challenge over the last few years. And I think my colleague Angela Zykowski, I think she referred to it as the Decker Towers effect. I represent Burlington Housing Authority. That was a challenging time for the housing authority. We had multiple evictions going, and this was one of the major problems. Drug dealer, and I gotta tell you, not the tenant, but people coming in from out of state, staying with the tenant, taking advantage, et cetera. Tenant gets evicted, goes in with somebody else, or the drug dealer moves to the next unit, to the next unit. So it is like this constant ping pong effect. The landlord has already gone through an expense of having to go through the eviction process. We want them gone, period, end of story. So I would go a step further in what's proposed in 772, which would be if have it written right, we could put it right in the court order. If it's in the statute that says, if you have been evicted by court order, you cannot, period, return to the property, or you will be deemed trespassing. I don't support having them serve with a trespass notice, because if they're not there at the lockout, then we gotta find them, and then it's this constant, chase to try to get them down. I do have Windsor County Sheriff, I think is the only sheriff right now, and again, I cover 13 out of the 14 counties, and I think Windsor County is the only sheriff right now that has, when they do a lockout for me, they give me a form. It says when the lockout was completed, who was present, what happened, possession returned to the landlord at this date and time. Bam, right there. There's your notification that the eviction is complete. And then we could add something to that form or something, and it would be in the court order that would say the tenant can't come back after lockout. Because I can tell you the break-ins are on the rise. They come back, they break in, we have to board up. And they do damage. And again, these are the worst of the worst. Okay, I don't wanna be gloom and doom, but I deal with the worst of the worst. And I know Sheriff Gamlin's coming in next week. He has great pictures. What he sees is unbelievable. And it's gonna be very informative for you to hear from Sheriff Gamlin next week. But things are bad. They're really bad. And it's the effect on the neighbors. So in the cause case, especially for the trespass, if you can keep keep the tenants that have been evicted away, it gives solace and comfort for neighbors. Because how many calls do my property managers get? They're like, so-and-so was evicted, they're here, I'm scared. I mean, I represent, again, the nonprofits and the subsidized housing. I've got senior buildings. I've got seniors, I've got families, I cover it all. So how can you make them safe, keep them, or feel safer? Would you want your mother or something in a building where her neighbors like got a drug dealer living with her? I mean, it's bad, but it can happen, right? So, yeah. But again, I want to preface, there are a lot of wonderful tenants. There are a lot of wonderful landlords. And it's like anything else, it's like 10% of the population, and if it's not payment, we're gonna work with them, right? We'll work with you, we'll figure it out. Just give us a shorter process. We still have time to do it. We still have time to work with them, hook them up with programs, things like that, but shorter process would be great. I think we covered all the main topics that I wanted to cover.
Thank
Do you have any other questions? Are there any other questions?
Well, thank you so much. Thank you.
Oh, awesome. Thank you. Oh, no. And if I can help with any, like, the technical piece, drafting, I don't know if Cameron with you on this.
I don't know.
If I can help with any sort of drafting or anything, just very reach out to me.
If you're staying up at night, you
So we'll have back at 1 o'clock, to talk about, the